Outstanding features of our Constitution: 35 certain states, such as Nagaland, Assam, Manipur, Andhra Pradesh, Maharashtra, Gujarat, Sikkim, Mizoram, etc. We, not only are the provisions relating to die units elaborately given, federal relations tendencies between the federation and the units elaborately dealt a, the units inter se, whether legislative or administrative, are also exhaustively codified, so as to eliminate conflicts as far as possible. Lessons drawn from the political history of India which induced the framers of the constitution to give it a unitar bias, also prompted them to make detailed provisions regarding the distribution of powers and functions between the union and the states in all aspects of their administrative and other activities. 6. And also as regards interstate relations, coordination and adjudication of disputes amongst the states. 6. There is not only a Bill of Rights containing justiciable fundamental both justiciable rights of the individual, Part 3, on die model of die and non-justicia amendments to the American Constitution, but also a Bill of Rights include Part 4, containing directive principles, which fundamental confer no justiciable rights upon die individual but are Reg *vi0 be regarded as fundamental in the principles, fundamental duties, and governance of the country, being in the nature of principles of social policy as contained in the Constitution of i.e., the Republic of Ireland. It was considered by the makers of our Constitution that they could not, owing to their very nature, be made legally enforceable. It was well worth to incorporate in the Constitution some basic non-justiciable rights which would serve as moral restraints upon future governments and thus prevent the policy from being torn away from the idea which inspired the makers of the organic law. Even the Bill of Rights, i.e., the list of fundamental rights, became bulkier than elsewhere because the framers of the Constitution had to include novel matters owing to the peculiar problems of our country, e.g., untouchability, preventive detention. To the foregoing list, a notable addition has been made by the 42nd Amendment inserting one new chapter of Fundamental Duties of Citizens /Part IVA, Art. 5.1a, which though not attended with any legal sanction, have now to be read along with the fundamental rights. See, further, under Chap 8, Post. More flexible than rigid. For another distinctive feature of the Indian Constitution is that it seeks to impart flexibility to a written federal constitution. It is only the amendment of a few of the provisions of the Constitution that requires ratification by the state legislatures, and even then ratification by only a half of them would suffice, while the American Constitution requires ratification by 3rd April of the states.
The rest of the Constitution may be amended by a special majority of the Union Parliament, i.e., a majority of not less than 2nd March of the members of the each house present and voting, which, again, must be majority of the total membership of the house, see Chap 10. On the other hand, Parliament has been given the power to alter or modify many of the provisions of the Constitution by a simple majority as is required for general legislation, by laying down in the Constitution that such changes shall not be deemed to be amendments of the Constitution. Instances to the point are a. Changes in the names, boundaries, areas of, and amalgamation and separation of states, Art 4. B. Abolition or creation of the second chamber of the state legislature, Art 169. C. Administration of scheduled areas and scheduled tribes, Para 7 of the 5th schedule and Para 21 of the 6th schedule. D. Creation of legislatures and council of ministers for certain union territories, Art 239a. 2. Yet another evidence of this flexibility is the power given by the Constitution itself to Parliament to supplement the legislation as times are supplementing the provisions of the Constitution by legislation. The makers of the Constitution aimed at exhaustiveness, they realized that it was not possible to anticipate all exigencies and to lay down detailed provisions in the Constitution to meet all situations and for all times. A. In various articles, therefore, the Constitution lays down certain basic principles and empowers Parliament to supplement these principles by legislation. Thus, I, as to citizenship, Arts. 5-8 only lay down the conditions for acquisition of citizenship at the commencement of the Constitution and Art. 11 West's plenary, powers in Parliament to legislate on this subject. In pursuance of this power, Parliament has enacted the Citizenship Act, 1955, so that in order to have a full view of the law of citizenship in India, study of the Constitution has to be supplemented by that of the Citizenship Act. 2. Similarly, while laying down certain fundamental safeguards against preventive detention, Art. 22(7) empowers Parliament to legislate on some subsidiary matters relating to the subject. The laws made under this power have, therefore, to be read along with the provisions of Art. 22(3) again, while banning untouchability, Art. 17 provides dial it shall be an offence punishable in accordance with law, and in exercise of this power, Parliament has enacted the Protection of Civil Rights Act, 19,557, which must be referred to as supplementing the constitutional prohibition against untouchability. 4. While the Constitution lays down the basic provisions relating to the election of the President and Vice President,
Art. 71(3) empowers Parliament to supplement these constitutional provisions by legislation, and by virtue of this power Parliament has enacted the Presidential and Vice Presidential Elections Act, 1952. The obvious advantage of this scheme is that the law made by Parliament may be modified according to the exigencies for the time being, without having to resort to a constitutional amendment. B. There are, again, a number of articles in the Constitution which are of a tentative or transitional nature and they are to remain in force only so long as Parliament does not legislate on the subject, e.g., exemption of union property from state taxation, Art. 285, suability of the state.
The Constitution, thus
ensures adaptability by prescribing a variety of modes in which its original text may be changed or supplemented, a fact which has evoked approbation from Professor Weir. This variety in the amending process is wise but is rarely found. This wisdom has been manifested in the ease with which Sikkim, a protectorate since British days, could be brought under the Constitution first, as an associate state, 35th Amendment Act, and then as a full-fledged state of the Union, 36th Amendment Act, 1975. Reconciliation of a. This combination of the theory of written fundamental law which underlies the written with Parlia Constitution of the United States with the theory of parliamentary sovereignty which underlies the unwritten Constitution of England is the result of the liberal philosophy of the framers of the Indian Constitution, which has been so nicely expressed by Pandit Nehru. While we want this Constitution to be as solid and permanent as we can make it, there is no permanence in constitutions. There should be a certain flexibility. If you make anything rigid and permanent, you stop the nation's growth, the growth of a living, vital, organic people. In any event, we could not make this constitution as rigid that it cannot be adapted to changing conditions. When the world is in turmoil and we are passing through a very swift period of transition, what we may do today may not be wholly capable tomorrow. 9. The flexibility of our Constitution is illustrated by the fact that during the first 59 years of its working, it has been amended 94 times. Vital changes have thus been effected by the 1st, 4th, 24th, 25th, 39th, 42nd, 44th, 73rd and 74th Amendments to the Constitution, including amendments to the fundamental rights, powers of the Supreme Court and the High Courts. Dr. Jennings 111 characterized our Constitution as rigid for two reasons. A. that the process of amendment was complicated and difficult, b. that matters which should have been left to ordinary legislation having been incorporated into the Constitution. No change in these matters is possible without undergoing the process of amendment. We have seen that the working of the Constitution during 6 decades has not justified the apprehension that the process of amendment is very difficult. See also Chap 10, Post, but the other part of his reasoning is obviously sound. In fact, his comments on this point have
proved to be prophetic.
He cited Art. 224 as an illustration of a provision which had been unnecessarily embodied in the Constitution. An example taken at random is Article 224, which empowers a retired judge to sit in a high court. Is that a provision of such constitutional importance that it needs to be constitutionally protected, and be incapable of amendment except with the approval of 2/3 of the members of each house sitting and voting in the Union Parliament? 1. As Table 4 will show, it has required an amendment of the Constitution, namely, Tier 7th. Amendment of 1956, to amend this article to provide for the appointment of additional judges instead of recalling retired judges. Similar amendments have been required, once to provide that a judge of a high court who is transferred to another high court shall not be entitled to compensation, Art. 222, and, again, to provide for compensation. It is needless to multiply such instances since they are numerous. The greatest evidence of flexibility, however, has been offered by the amendments since 1976. The 42nd Amendment Act, 1976, after the Constitution had worked for over a quarter of a century, introduced vital changes and upset the balance between the different organs of the state. 11 Of course, behind this flexibility, lies the assumption that the party in power wields more than a 2/3 majority in both houses of Parliament. 1*6. It is also remarkable that though the framers of the Constitution attempted to make an exhaustive code of organic law, Hone's degree under, no high room must be left for the growth of conventions to Constitution. Supplement the Constitution in matters where it is silent. Thus, while the Constitution embodied the doctrine of cabinet responsibility in Art. 75, it was not possible to codify the numerous conventions which answer the problems as they may arise in England, from time to time, in the working of the cabinet system. Take, for instance, the question whether the ministry should resign whenever there is an adverse vote against it in the House of the People, or whether it is at liberty to regard an accidental defeat on a particular measure as a snap vote. 12 Again, the Constitution cannot possibly give any indication as to which issue should be regarded as a vital issue won by a ministry, so that on a defeat on such an issue the ministry should be morally bound to resign. Similarly, in what circumstances a ministry would be justified in advising the President to dissolve Parliament instead of resigning upon an adverse vote, can only be established by convention. Sir Ivor Jennings 10 is, therefore, justified in observing that the machinery of government is essentially British and the whole collection of British Constitution conventions has apparently been incorporated as conventions. While the directive principles are not enforceable in die courts, the fundamental rights, included in Part 3, are so enforceable at the instance of any person whose fundamental right has and constitutive been infringed by any action of the state, executive constitutional remedies, or legislative, and the remedies for enforcing these rights, namely, the writs of habeas corpus, mandamus, prohibition, quo warranto and certiorari, are also guaranteed by the Constitution. Any law or executive order which offends against a fundamental right is liable to be declared void by the Supreme Court or the High Court. It is through a misapprehension of these provisions that the Indian Constitution has been described by some critics as a lawyer's paradise. 12 According to Sir Ivor Jennings 10, this is due to the fact that the Constituent Assembly was dominated by the lawyer politicians. It is they who thought of codifying the individual rights and the prerogative writs, though none in England would ever cherish such an idea, Hide the words of Sir Ivor. Though no English lawyer would have thought of putting the prerogative writs into a constitution, the Constituent Assembly did so. These various factors have given India a most complicated constitution. Those of us who claim to be
Constitutional
lawyers can look with equanimity on this exaltation of our profession. But constitutions are intended to enable the process of government to work smoothly, and not to provide fees for constitutional lawyers. The more numerous the briefs, the more difficult the process of government becomes. India has perhaps placed too much faith in us. 10. With due respect to the great constitutional expert, 10. These observations disclose a failure to appreciate the very foundation of the Indian Judicial Review Constitution. Sir Ivor omits to point out that the makes the Committee fathers of the Indian Constitution preferred the Tuscan legalistic American doctrine of limited government to the English doctrine of parliamentary sovereignty. In England, the birth of modern democracy was due to a protest against the absolutism of an autocratic executive, and the English people discovered in parliamentary sovereignty an adequate solution of the problem that faced them. The English political system is founded on the unlimited faith of the people in the good sense of their elected representatives. Though of late, distractions from its omnipotent authority have taken place because the ancient institution at Westminster has grown incapable of managing myriads of modern problems with the same ease as in Victorian age. Nonetheless, never has anybody in England thought of placing limitations on the authority of Parliament so that it might properly behave. The founding fathers of the American Constitution, on the other hand, had the painful experience that even a representative body might be tyrannical, particularly when they were concerned with the colonial empire. Thus it is that the Declaration of Independence recounts the attempts of the British legislature to extend an unwarrantable jurisdiction over us, and how the British people had been deaf of the voice of justice. At heavy cost had the colonists learned about the frailty and weakness of human nature when the same Parliament which had forced Charles I to sign the Petition of Right, 1G28, to acknowledge that no tax could be levied without the consent of Parliament, did, in 17G5, and the years that followed, insist on taxing the colonies, regardless of their right of representation, and attempt to enforce such undemocratic laws that military rule. Hence, while the English people, in their fight for freedom against autocracy, stopped with the establishment of the supremacy of the law and Parliament as the sole source of that law, Americans had to go further and to assert that there is to be a law superior to the legislature itself, and that it was the restraints of this paramount written law that could only save them from the fears of absolutism and autocracy which are ingrained in human nature itself. As will be more fully explained in the chapter on fundamental rights, the Indian experience of the application of the British rule of law in India was not altogether happy, and there was a strong feeling that it was not administered with even hands by the foreign rulers in India as in their own land. The Sons of Liberty in India had known to what use the flowers of the English democratic system, viz., the sovereignty of Parliament and the rule of law, could be put in trampling down the rights of man under imperial rule. So, in 1928, long before the dawn of independence in India, the Motilal Nehru Committee asserted that our first care could be to have our fundamental rights guaranteed in a manner which will not permit their withdrawal under any circumstances. Now, judicial review is a necessary concomitant of fundamental rights, for it is meaningless to enshrine individual rights in a written constitution as fundamental rights if they are not enforceable in courts of law against any organ of the state, legislative or executive. Once this choice is made, one cannot help to be sorry for the litigation that ensues. Whatever apprehensions might have been entertained in some quarters in India at the time of the making of the Indian Constitution, there is hardly anybody in India today who is aggrieved because the Supreme Court, each year, invalidates a dozen of statutes and a like number of administrative acts on the ground of violation of the fundamental rights. At the same time, it must be pointed out that since the inauguration of the Constitution, various provisions have been inserted into the Constitution by amendments, which have taken out considerable areas from the pale of judicial review, e.g., by inserting Arts. 31A 31C, and by 1995 as many as 284 acts, central and state, have been shielded from judicial review on the ground of contravention of the fundamental rights, by enumerating them under the 9th schedule, which relates to Art. 3IB.11 VTII. An independent judiciary, having the power of judicial review, is another prominent feature of our Constitution. On the other hand, we have avoided the other extreme, namely, that of judicial supremacy, which may be a logical outcome of an overemphasis on judicial review, as the American experience demonstrates. Judicial power of the state exercisable by the courts under the Constitution as sentinels of rule of law is a basic feature of the Constitution. 1 *. Indeed, the harmonization which our Constitution has effected between parliamentary sovereignty and a written Constitution compromise bet with the provision for judicial review, is a unique review and achievement of the framers of our Constitution. An parliamentary absolute balance of powers between the different supremacy organs of government is an impracticable thing and, in practice, the final say must belong to some one of them. This is why the rigid scheme of separation of powers and the checks and balances between the organs in the Constitution of the United States has failed in its actual working, and the judiciary has assumed supremacy under its powers of interpretation of the Constitution to such an extent as to deserve the epithet of the safety valve or the balance wheel of the Constitution. As one of her own judges has said, Chief Justice Hughes, the Constitution of the USA is what the Supreme Court says it is. It has the power to invalidate a law duly passed by the legislature not only on the ground that it transgresses the legislative powers vested in it by the Constitution or by the prohibitions contained in the Bill of Rights, but also on the ground that it is opposed to some general principles said to underlie vague expressions, such as due process, the contents of which not being
explicitly
laid down in the Constitution, are definable only by the Supreme Court. The American judiciary thus sits over the wisdom of any legislative policy as if it were a third chamber or super chamber of the legislature. Under the English Constitution, on the other hand, Parliament is sovereign and can do everything that is not naturally impossible, extant, and the courts cannot nullify any act of Parliament on any ground whatsoever. As May puts it, the Constitution has assigned no limits to the authority of Parliament over all matters and persons within its jurisdiction. A law may be unjust and contrary to the principles of sound government. But Parliament is not controlled in its discretion, and when it is, its errors can be corrected only by itself. So, English judges have denied themselves any power to sit as a court of appeal against Parliament. The Indian Constitution wonderfully adopts the via media between the American system of judicial supremacy and the English principle of parliamentary supremacy, by endowing the judiciary with the power of declaring a law as unconstitutional if it is beyond the competence of the legislature according to the distribution of powers provided by the Constitution, or if it is in contravention of the fundamental rights guaranteed by the Constitution or of any other mandatory provision of the Constitution, e.g., Arts. 286, 299, 301, 304, but, at the same time, depriving the judiciary of any power of judicial review of the wisdom of legislative policy. Thus, it avoided expressions like due process, and made fundamental rights such as that of liberty and property subject to regulation by the legislature. 11 But the Supreme Court has discovered due process in Art. 21 in Maneka Gandhi. 14 Further, the major portion of the Constitution is liable to be amended by the Union Parliament by a special majority, if in any case the judiciary proves too obtrusive. The theory underlying the Indian constitution in this respect can hardly be better expressed than in the words of Pandit Nehru: no Supreme Court, no judiciary, can stand in judgment over the sovereign will of Parliament, representing the will of the entire community. It can pull up that sovereign will if it goes wrong, but, in the ultimate analysis, where the future of the community is concerned, no judiciary can come in the way. Ultimately, the fact remains that the legislature must be supreme and must not be interfered with by the courts of law in such measures as social reform. Our constitution thus places the supremacy at the hands of the legislature as much as that is possible within the bounds of a written constitution. But, as has been mentioned earlier, the balance between parliamentary sovereignty and judicial review and is seriously disturbed, and a drift towards the former was made, by the Constitution, 42nd Amendment, Act, 1976, BB inserting some new provisions, e.g., Arts. 3 ID 32131A, 144A.226A, 228A.323AB, 329A. The Janata government, coming to power in 1977, restored the pre-1976 position
to a substantial
extent, derived the 43rd and 44 DT amendments, 1977 to 78. BB repeating the following articles which had been inserted by the 42nd Amendment 3 ID, 32 a 131 a 144A. 226 a 228 a 329A, and by restoring Art. 226 to its original form. On the other hand, the judiciary has gained ground by itself, declaring that judicial review is a basic feature of our constitution, so that so long as the Supreme Court itself does not revise its opinion in this behalf, any amendment of the constitution to take away judicial review of legislation on the ground of contravention of any provision of the constitution shall itself be liable to be invalidated by the court. See at the end of this chapter. Fundamental 9. The balancing between supremacy of the rights subject to constitution and sovereignty of the legislature is reasonable regular illustrated by the novel Declaration of Fundamental Lacher. ER1's rights which our constitution embodies. The idea of incorporating in the constitution a Bill of Rights has been taken from the Constitution of the United States. But the guarantee of individual rights in our constitution has been very carefully balanced with the need for the security of the state itself. American experience demonstrates that a written guarantee of fundamental rights has a tendency to engender an atomistic view towards society and the state which may at times prove to be dangerous to the common welfare. Of course, America has been saved from the dangers of such a situation by reason of her judiciary propounding the doctrine of police powers, under which the legislature is supposed to be competent to interfere with individual rights wherever they constitute a clear danger to the safety of the state and other collective interests. Instead of leaving the matter to the off chance of judicial protection in particular cases, the Indian Constitution makes each of the fundamental rights subject to
control under the terms of the Constitution itself, apart from those exceptional cases where the interests of national security, integrity or welfare should exclude the application of fundamental rights altogether. Arts. 31A 31C. 11X. Another peculiarity of the chapter on fundamental rights in the Indian Constitution is that it aims at securing not social equality merely political or legal equality, but social equality as the constitution. Asterisk well. Thus, apart from dire usual guarantees that the state will not discriminate between one citizen and another merely on the ground of religion, race, caste, sex or place of birth, in the matter of appointment or other employment offered by the state, the Constitution includes a prohibition of untouchability in any form and lays down that no citizen may be deprived of access to any public place, of the enjoyment of any public amenity or privilege, only on the ground of of religion, race, caste, sex or place of birth. We can hardly overlook in this context that under the Constitution of Tire USA, racial discrimination persists even today, notwithstanding recent judicial pronouncements to the contrary. The position in the United Kingdom is no better as demonstrated by current events. Fundamental 11. Another feature, which was not in the rights checkmark original constitution, has been introduced by the 42nd 10th by Funda Amendment 1976 by introducing Art. 5.1 as part mental duties. IBA of the Constitution.
Though the directives in Part 4 of the Constitution were not enforceable in any manner and had to give way before the 1976 CN fundamental rights, under the original Constitution, the situation was reversed, through die backdoor, by the 42nd Amendment, 1976, by amending Art. 31C1 shielding all the directives in Part 4 of the Constitution from the fundamental rights in Part 3. But this object has been frustrated by the majority decision in the case of Minerva Mills v Union of India 1, as a result of which Art. 31C will shield from unconstitutionality on the ground of violation of Art. 13 those laws which implement only the directives specified in Art. 39 B-C, and not any other directive included in Part 4 of the Constitution. In the same direction, the 42nd Amendment Act introduced fundamental duties, to circumscribe the fundamental rights, even though the duties, as such, cannot be judicially enforced. See, further, under Chap 8, Post. 12 the adoption of universal adult suffrage, Art 326, without any qualification either of sex, property, taxation or the choice 03 without a bold experiment, in India, having regard to communal repray the vast extent of the country and its population, with sanitation, an overwhelming illiteracy, see Table I, Post. The suffrage in India, it should be noted, is wider than that in England or the United States. The concept of popular sovereignty, which underlies the declaration in the preamble that the Constitution is adopted and given by the people of India, unto themselves, would indeed have been hollow unless the franchise, the only effective medium of popular sovereignty in a modern democracy, were extended to the entire adult population which was capable of exercising the right, and an independent electoral machinery, under the control of the Election Commission, was set up to ensure the free exercise of its. The electorate has further been widened by lowering the voting age from 21 to 18, by the 61st Constitution Amendment Act, 1988. That, notwithstanding the outstanding difficulties, this bold experiment has been crowned with success.
This will be evident from some of the figures 16 relating to the first general election held under the Constitution in 1952.
Out of a total population of 356 million and an adult population of 180 million, the number of voters enrolled was 173 million, and of these no less than 88 million, i.e., over 50% of the enrolled voters, actually exercised their franchise. The orderliness with which 11 general elections have been conducted speaks eloquently of the political attainment of the masses, though illiterate, of this vast subcontinent. In the 11th general election held in 1996, the number of persons on the electoral roll had come up to 550 million, and the same came up to 67 crores 14,87,930 in the 14th general election in 2004. No less creditable for the framers of the Constitution is the abolition of communal representation, which in its trail had brought in the bloody and lamentable partition of India. In the new constitution there was no reservation of seats except for the scheduled castes and scheduled tribes and for the Anglo-Indians, and that only for a temporary period. period was 10 years in the original constitution, which has been extended to 60 years, i.e., up to 2010 AD, by subsequent amendments of Art. 334.1713. It has been stated at the outset that the form of government introduced by our constitution both at the Union and the States is the parliamentary government of the British type. A primary reason for the choice of this system of government was that the people had a long experience of this system under the Government of India Acts 1 *, though the British were very slow in importing its features to the fullest length. The makers of our constitution rejected the presidential system of government, as it obtains in America, on the ground that under that system the executive and the legislatures are separate from and independent of each other, which is likely to cause conflicts between them, which our infant democracy could ill afford to risk. But though the British model of parliamentary or cabinet form of government was adopted, a hereditary monarch or ruler at the head could not be installed, because India had declared herself a republic. Instead of a monarch, therefore, an elected president was to be at the head of the parliamentary system. Introducing these amalgam, the makers of our constitution followed the Irish precedent. As in the constitution of A, the Indian constitution superimposes an elected president upon the parliamentary system of responsible government. But though an elected president is the executive head, parliamentary GFJ in Joel, vertical bar lay, 0 AC, on advice of his combinative and ministers, although whether he so acts according to elected presidential advice of his ministers is not questionable in the at the head courts, and there is no mode, short of impeachment, to remove the president if he acts contrary to the constitution. On the other hand, principle of ministerial responsibility to the legislature, which under the English system rests on convention, is embodied in the express provisions of our constitution, Art 75, 3, vertical bar. In the words of our Supreme Court, while our constitution, though federal in its structure, is modelled on the British parliamentary system where the executive is deemed to have the primary responsibility for the formulation of government policy and its transmission into law, though the condition precedent to the exercise of this responsibility is its retaining the confidence of the legislative branch of the state. In the Indian constitution, therefore, we have the same system of parliamentary executive as in England. But our constitution is not an exact replica of the Irish model either. The constitution of Ireland lays down the constitutional powers of the president can only be exercised by him on the advice of ministers, except those which are left to his discretion by the constitution itself. The Irish president has an absolute discretion to refuse dissolution of the legislature to a defeated prime minister, contrary to the English practice and convention. But in the Indian constitution there is no provision 19, amendment authorizing the president to act in his discretion on any matter. On the other hand,
Art.
74. 1. The 42nd Amendment Act has explicitly codified the proposition which the Supreme Court has already laid down in several decisions. 1. That the President shall, in the exercise of his functions, act in accordance with such advice, i.e., the advice tendered by the Council of Ministers. The Janata government has preferred not to disturb this contribution of the 42nd Amendment, except to empower the times 40th Amendment, 1978 President by the 44th Amendment, 1908, to refer a matter back to the Council of Ministers, for reconsideration. 14. Perhaps the most remarkable achievement of the Indian Constitution is to confer upon a federal system the strength of unitary government.
A federal
system, though normally the system of government is federal, with unitary bias. The Constitution enables the federation to transform itself into a unitary state, by the assumption of the powers of states by the Union, in emergencies, Part 15(1). Such a combination of federal and unitary systems in the same Constitution is unique in the world. For a correct appreciation of this unique system, it is necessary to examine the background upon which federalism has been introduced into India, in the light of the experience in other federal countries. This deserves a separate treatment, see CLIAP 5, post 15. No less an outstanding feature of the new constitution is the union of some 552 Indian states with the rest of India under the constitution. Integration of thus, the problem that baffled the framers of the Indian states. Government of India Act, 1935, and ultimately led to the failure of its federal scheme, was solved by the framers of the constitution with unique success. The Enbar subcontinent of India has been unified and consolidated into a compact state in a manner which is unprecedented in the history of this country. The process by which this formidable task has been formed makes a story in itself. At the beginning of the constitutional reforms leading to the Government of India Act, 1935, the geographical entity known as India was divided into two status of Indian parts, British India and the Indian states. While states under the BNDSH India comprised the 9 governors provinces British Crown, and some ODI areas administered by the Government of India itself. The Indian states comprised some 600 states which were mostly under the personal rule of the rulers or proprietors. All the Indian states were not of the same order. Some of them were Swiss under the rule of hereditary chiefs, which had a political status even from before the Mohammedan invasion. Others, about 300 in number, were estates or jagas granted by the rulers as rewards for services or otherwise, to particular individuals or families. But the common feature that distinguished these states from British India was that the Indian states had not been annexed by the British Crown. So, while British India was under the direct rule of the Crown derived its representatives and according to the statutes of Parliament and enactments of the Indian legislatures, the Indian downloaded from W. States were allowed to remain under the personal rule of their chiefs and princes, under the suzerainty of the Crown, which was assumed over the entire territory of India when the Crown took over authority from the East India Company in 1858. The relationship between the Crown and the Indian states since the incidence of para assumption of suzerainty by the Crown came to be mouncy, described by the term paramountcy. The Crown was bound by engagements of a great variety with the Indian states. A common feature of these engagements was that while the states were responsible for their own internal administration, the Crown accepted responsibility for their external relations and defense. The Indian states had no international life, and for external purposes, they were practically in the same position as British India. As regards internal affairs, the policy of the British Crown was normally one of non-interference with the monarchical rule of the rulers, but the Crown interfered in cases of misrule and maladministration, as well as for giving effect to its international commitments. So, even in the internal sphere, the Indian states had no legal right against non-interference. Nevertheless, the rulers of the Indian states enjoyed certain personal rights and privileges, and normally carried on their personal administration, unaffected by all political and constitutional vicissitudes within the neighbouring territories of British India. The Government of India Act, 1935 envisaged a federal structure for the whole of India, in which the Indian states could figure as units, to get a place of Indian states in the federal scheme proposed by the Government of India Act, 1935, with the governors' provinces. Nevertheless, the framers of the Act differentiated the Indian states from the provinces in two material respects, and these differentiation ultimately proved fatal for the scheme itself. The 2 points of asterisk difference were, a. While in the case of the provinces accession to the federation was compulsory or automatic, in the case of an Indian state it was voluntary and depended upon the option of the ruler of the state, b. w. While in the case of the provinces, The authority of the federation over the provinces, executive as well as legislative, extended over the whole of the federal sphere chalked out by the Act.
In the case of the Indian states, the authority of the federation
could be limited by the instrument of accession, and all residuary powers belonged to the state. It is needless to elaborate the details of the plan of 1935, for, as has been stated earlier, the accession of the Indian states to the proposed federation never came true, and this part of that act was finally abandoned in 1939, when World War II broke out. When
Cripps came to India with the loose plan, it was definitely understood that the plan proposed by him would be confined to settling the political destinies of British India, and that the Indian states would be left free to retain their separate status. Proposal of the Cabinet Mission. But the Cabinet Mission supposed I and the Indian states would be ready to cooperate with the new development in India. So, they recommended that there should be a union of India, embracing both British India and the states, which would deal only with foreign affairs, defense and communications, while the state would retain all powers other than these. Lapse of power. When the Indian Independence Act, 1947, was Mount C under the past, it declared the lapse of suzerainty, para Indian Independence Mount C, of the Crown, in S7, 1b, of the Act, which then Act. Jail's reproduction, 7i, as from the appointed date, the suzerainty of His Majesty over the Indian states lapses, and with it, all treaties and agreements in force at the date of the passing of this Act between His Majesty and the rulers of Indian states, all functions exercisable by His Majesty at the date with respect to Indian states, all obligations of His Majesty existing at that date towards Indian states
or the rulers thereof, and all powers, rights, authority, or jurisdiction
the rulers thereof
exercisable by His Majesty at that date in or in relation to Indian states by treaty, grant, usage, sufferance or otherwise, and provided that notwithstanding anything in paragraph A of this subsection, effect shall, as nearly as may be, continue to be given to the provision of any such agreement as is therein referred to, which relate to customs, transit and communications, posts and telegraphs, or other like matters, until the provisions in question are denounced by the rulers of the Indian states, on the one hand, or by the dominion or province or other part thereof concerned on the earlier hand, or are superseded by subsequent agreements. But though paramount C lapsed and the Indian states regained their position which they had prior to the assumption of suzerainty by the Crown, most of the states soon realized that it was no longer possible for them to maintain their existence independent of and separate from the rest of the country, and that it was in their own interests necessary to accede to either of the two dominions of India and Pakistan. Of the states situated within the geographical boundaries of the Dominion of India, all, numbering 552, save Hyderabad, Kashmir, Bahawalpur Jingad and the NWF states, Chitral, Fulra, Dir, Swat and Amb, had acceded to the Dominion All India by the 15th August 1947, it, before the appointed Dove itself. The problem of the government of India as regards tier states after accession was twofold: a. Shaping the Indian states into sizable or viable administrative ohits, and b. Fitting them into the constitutional structure of India. The first objective was sought to be achieved by a threefold process of integration, known as the Patel Scheme after Sardar Vallabhbhai Patel, Minister in charge of Home Affairs. 216 states were merged into the respective provinces, geographically contiguous to them. These merged states were a majority asterisk included in the territories of die states in Part B in the first schedule of the Constitution. The process of merger started with the merger of Orissa and Chhattisgarh states with the then province of Orissa on 1 January 1948, and the last instance was the merger of Cooch Behar with the state of West Bengal in January 1950. 2. 61 states were converted into centrally administered areas and included in Part C of the first schedule of the Constitution. This form of integration was resorted to in those cases in which, for administrative, strategic or other special reasons, central control was considered necessary. The third form of integration was the consolidation of groups of states into new viable units, known as Union of States. The first union formed was the Saurashtra Union, consolidating the Kathiawar states and many other states, 15th February 1948, and the last one was the Union of Travancore-Cochin, formed on 1st July 1949. As many as 275 states were thus integrated into 5 unions: Madhya Bharat, Patiala and East Punjab States Union, Rajasthan, Saurashtra and Travancore-Cochin. These were included in the states in Part B of the first schedule. The other 3 states included in Part B were Hyderabad, Jammu and Kashmir and Mysore. The cases of Hyderabad and Jammu and Kashmir were peculiar. Jammu and Kashmir acceded to India on October 2, 1947, and so it was included as a slate in Part B, but the Government of India agreed to take the accession subject to confirmation by the people of the state, and the Constituent Assembly subsequently confirmed it, in November 1956. Hyderabad did not formally accede to India, but the Nizam issued a proclamation recognizing the necessity of entering into a constitutional relationship with the Union of India and accepting the Constitution of India subject to ratification by the Constituent Assembly of Dial State, and the Constituent Assembly of Dial State ratified this. As a result, Hyderabad was included as a state in Part B of the first schedule of the Constitution. States in Part B were formed as viable units of administration, being the residue of the bigger Indian states, left after the smaller states had been merged in the provinces or converted into centrally administered areas. So far as the latter 2 groups were concerned, there was no problem in fitting them into the body of the constitution framed for the rest of India. There was an agreement between the Government of India and the ruler of each of the states so merged, by which the rulers voluntarily agreed to the merger and ceded all powers for the governance of the states to the Dominion government, reserving certain personal rights and privileges for themselves. But the story relating to the states in Part B is not yet complete. At the time of their accession to the Dominion of India in 1947, the states had acceded only on the subjects, viz., defense, foreign affairs and communications. With the formation of the unions and under the influence of political events, the rulers found it beneficial to have a closer connection with the Union of India, and all the Raj Pramukhs of the unions as well as the Maharaja of Mysore signed revised instruments of accession BV, which all these states acceded to the Dominion of India in respect of all matters included in the union and concurrent legislative lists, except only those relating to taxation. Thus, the states in Part B were brought at par with the states in Part A, subject only to the differences embodied in Art. 238 and the supervisory powers of the Centre for the transitional period of 10 years /Art. 3711. Special provisions were made only for Kashmir, Art. 370, in view of its special position and problems. That article makes special provisions for the partial application of the Constitution of India to that state, with the concurrence of the government of that state. It is to be noted that the Raj Pramukhs of the 5 unions as well as the rulers of Hyderabad, Mysore, Jammu and Kashmir all adopted the Constitution of India, by proclamation.
The process
of integration culminated in the Constitution, 7th Amendment, Act, 1956,
which abolished failed
G states as the Senkati Sanisat. N degree C asterisk as included all the states in Part A and are in one list. N the special provisions in the Constitution relating to Part B states were, consequently, omitted. The Indian states thus lost their identity and became part of one uniform political organization embodied in the Constitution of India. 2J The process of reorganization is continuing still, and the recent trend is towards conceding the demands of smaller units which were previously Part B states, union territories or autonomous parts of states, by conferring upon them the status of a state, e.g., Nagaland, Meghalaya, Himachal Pradesh, Manipur, Tripura, Mizoram, Goa. Delhi has been made the National Capital Territory. This process will be further elaborated in Chap. 6. Territory of India, Post. Before closing this chapter, however, it should be pointed out that since the observations in the case of Golaknath 4 times Basalk Fe, a loose asterisk of culminating with Keshwananda, the Supreme Court, the Constitution, had been urging that there are certain basic features of the Constitution, which were immune from the power of amendment conferred by Art. 368, which, according to the court, was subject to implied limitations. On the other hand, the Indira government had been attempting to thwart this doctrine by successive amendments of Art. 368, starting with the 24th Amendment, 1971. And ending with 42nd Amendment Act, 1976, so as to obviate any such conclusion by the Supreme Court. 26 The court has, however, adhered to its view notwithstanding any of these amendments. 27 The present chapter does not enter into that controversy, which will be dealt with in Chap. 10, Procedure for Amendment, Post. See that chapter as to the list of basic feature. The comparative study of any constitution will reveal that it has certain prominent features which distinguish it from other constitutions. It is those prominent features which have been summarized in this chapter by way of introducing the reader to the various provisions of the Indian Constitution.